So welcome everyone. First of all, just a quick sort of housekeeping note. This conversation will be conducted in English. And we do have many Israeli guests. But like we said, this will be in an English webinar. This is a webinar, not an ordinary Zoom meeting. That means that the participants who are not the panelists can't turn on their microphone or their camera or anything like that. If you do have questions, and you're of course welcome to write questions, there's a special Q&A button which you can add any questions to, whether during the remarks or in the conversation or afterwards, and please feel free to do so. We will occasionally write some things in the chat if they're relevant or useful for everybody, or links and some such. So let's get started. Today we're going to have a conversation with Professor Stephen Calabrese about comparative aspects of the proposals for judicial reform in Israel. This event is being hosted by the Israel Law and Liberty Forum. Just a few quick words about the Israel Law and Liberty Forum. The forum is a project by the Tikva Fund in Israel, where we advance a conservative legal worldview in Israel through informed and dignified and respectful and diverse debate. We build a community of like-minded legal conservatives and libertarians and classical liberals, as well as provide a platform for conservative legal thought, advancing the rule of law, judicial restraint, individual liberties, limited government, and separation of powers. I'm not going to say too much more about the Israel Law and Liberty Forum. We will put some links in the chat to register for the forum or to learn more about the forum. We'll put a link in there for our English language website, where you can sign up for our English language newsletter, or as well also our Hebrew language registration page, or Hebrew language site, where you can sign up for our Hebrew newsletter. Obviously, being in Israel, most of our programming and content is in Hebrew or for a Hebrew-speaking audience. But of course, we do, as you can see, occasionally also have programming of a more international nature. Of course, I always forget this part, just to introduce myself. I'm Jonathan Green. I'm executive director of the Israel Law Liberty Forum, and enough about that. About our guest today. So Professor Stephen Calabrese is professor of law at Northwestern University, and he's among the world's leading and most recognized scholars of comparative constitutional law. He's been teaching, He's been teaching a course of comparative constitutional law for at least 20 years, if not more, really, at universities, including Northwestern, Yale, and Brown. He has clerked for judges such as Robert Bork and Antonin Scalia. And I should say that he has, at least in many senses, quite written the book on comparative constitutional law. He's written many books and articles on various areas of constitutional law, both within the US and internationally. Just some examples are the US Constitution and Comparative Constitutional Law, which is an important textbook. And quite recently, he has published two large and significant tomes of comparative constitutional law called The History and Growth of Judicial Review, one volume which discusses the common law countries in Israel, the G20 common law countries and Israel, the other volume, the G20 countries of the civil or continental law tradition. And of course, last but not least, Professor Calabrese is one of the original founders of the Federalist Society in the US, upon which the Israel Law and Liberty Forum is modeled. And he is also a member of the International Advisory Board of the Israel Law and Liberty Forum. So welcome, Professor Calabrese.
Thank you, Jonathan. Many thanks to you for inviting me, and many thanks also to the Israel Law and Liberty Forum for all of the good work you do. I'm excited to be here and excited to be able to talk to you today about judicial reform.
Well, it's it's a pleasure having you on. I'm going to kick off with a really quick introduction, Professor Calabrese, and then just to sort of loop in our audience in terms of the general plan. After a quick introduction from me, Professor Calabrese will offer some remarks. I will continue the conversation with Professor Calabrese, and then we'll receive some questions from the audience. And so let's jump right in. I'll start off just by stating the obvious. We are in the midst of a momentous and fraught debate in Israel about our judiciary, about our system of government, and our very democratic character. The Israeli government has been advancing judicial reforms which include a number of different proposals and elements. And these have been met with vociferous objections, opposition, and protests. Now, the current proposals at their various stages of discussion and legislation include four main elements, which I will summarize in the briefest way possible. And this is, again, just to frame sort of exactly what's going on in Israel, but again, in a sort of in the most general terms possible. The first is changing the judicial selections process so as to eliminate the judicial veto currently held by serving judges on the Supreme Court, and so as to give elected and accountable representatives greater say over judicial appointments. The second element, I should call it, is reducing or annulling the reasonableness grounds for administrative judicial review. That is, this is judicial review of the executive, not of legislation, while leaving in place other traditional and familiar grounds for such judicial review. The third element is limiting the power of the legal counsel to the government office, such that their legal opinion remains advisory and is not binding on the government. And finally, the fourth element, if I can call it so, is defining the rules surrounding judicial review of legislation in Israel, how and when judges can strike down laws of parliament. And I should say this includes an expanded bench and a larger majority required for striking down laws. It includes reiterating that basic laws, or the quasi-constitutional basic laws, are non-justiciable and outside judicial review authority. It includes limiting the grounds of such judicial review to explicit statutory enumerated rights. So it prohibits judicial review based on broad interpretation, creating unenumerated rights, and some kind of override mechanism whereby Parliament can insist on a law remaining valid even after the court declares it unconstitutional. And that's, I think, the broadest and thinnest way possible, with very little nuance or sophistication, of describing the current proposals being discussed, again, in various stages. Now, just before we kick off into our conversation, I'd like to offer an observation about the public debate surrounding these proposals. One plane of the discussion involves reasonable and thoughtful disagreement about the proper and just role of the judiciary, about power wielded by unelected and unaccountable officials, about the correct and proper limits, the proper checks and limits on popular government, about the dangers of total legislative supremacy, etc. This layer of the debate can, in this layer of the debate, one can object to or support the various proposals, whether separately or taken as a whole. However, an entirely different plane involves the argument that these proposals, whether together or even each taken individually, are completely beyond the pale, that they mark a clear departure from established democratic norms and somehow undermine or even altogether destroy Israeli democracy. Now, regarding the second plane, I do feel obligated to highlight just how preposterous this argument is. Whatever one might think of these reforms, whatever valid objections one might have, it's worth keeping in mind some critical facts. The reforms grant more power to the elected, representative, and accountable branches of government, especially to the legislature. The reforms bring Israel closer to the way our legal system and our government system worked in the 1980s and the 1990s, hardly a time in which Israel was not considered a democracy. And the reforms would make Israel more aligned with democratic countries around the world. And I think these I think are a correct description on the factual level of the reforms. Now, this last point brings me to our conversation today with Professor Calabresi. A comparative perspective, informed by knowledge of legal systems and governments throughout the world, can make a critical contribution to the debate in Israel on both planes described above, both regarding the desirable or optimal governmental arrangements and addressing the argument that the proposed reforms would somehow undermine Israeli democracy. With that behind us, I now turn to Professor Calabresi to offer some remarks. Thank you very much.
Thank you, Jonathan, and thanks to the Law and Liberty Forum for hosting me. I am a great admirer of the Law and Liberty Forum and of all the good work you do, and I'm very happy to be here today. As Jonathan's opening remarks suggest, the state of Israel is facing what is probably the worst constitutional crisis in its history, at least since the meeting of the first Knesset. And I say that with deep sadness because I am of Italian Jewish origin, and I'm actually the first cousin twice removed of Professor Guido Tedeschi, the founder of the law school at Hebrew University. In addition to being related to Guido Tedeschi's daughter, who lives in Israel, I also have a second cousin who lives in Tel Aviv. I'm a passionate friend of Israel's and am deeply worried both that the country may be on the brink of civil war and that the overwhelming majority of Jewish Americans do not understand and are therefore vehemently opposed to Israel's judicial reforms as the government has presented them. I think the Netanyahu government has not done a very good job of drafting, explaining, and defending these reforms, either in the United States or in Israel. And I think there is, in addition, a problem that the criminal investigations into Prime Minister Netanyahu's affairs make him a flawed spokesperson for judicial reform. Having written a 2-volume Oxford University Press book about the history and growth of judicial review, I can quite confidently say that the Supreme Court of Israel is one of the most activist Supreme Courts in the world. It is too involved in the running of the executive branch. It claims the power to judicially review its constitutional amendments in the form of basic laws, and its Supreme Court justices play much too big a role in the selection of their own successors. To me, this means that Israel is a judicial oligarchy, not a republic or a democracy. The only other Supreme Court in the world which claims the power to judicially review constitutional amendments and to pick its own successors is the Supreme Court of India. India, unlike Israel, has a lengthy written constitution and Bill of Rights, and the framers of the Indian Constitution made it clear that they meant to authorize judicial review. The same cannot be said of Israel. As Lord Acton wrote, power tends to corrupt. Absolute power corrupts absolutely. The Israeli Supreme Court has been corrupted by the power it has usurped. In its lack of democratic legitimacy, the Israeli Supreme Court is unfortunately exactly like the Guardian Council of Iran, which selects that country's Ayatollah and which rules on which candidates can run for president and which candidates can't run for president. One of the many problems constitutional reformers face is that the Israeli Supreme Court, as it's currently constituted, will almost certainly strike down, in my opinion, any judicial reforms passed by the Knesset right now. And I am afraid that at that point, Prime Minister Netanyahu will walk away telling his right-wing coalition partners that he tried to get judicial reform passed, but failed. So I think those who really care about judicial reform need to come up with a judicial reform plan that the Supreme Court would not dare to strike down and that enjoys widespread popular support in Israel. That means a judicial reform that would really empower the people of Israel in picking judges. Judicial reform has to be so popular that the Supreme Court will not dare to invalidate it. I recommend, contrary to the proposals that the government has put forward, that a basic law be passed by the Knesset, providing that the president of Israel should be elected by the people of Israel to no more than 2 4-year terms. I would schedule the first presidential election 90 days after the passage of the new basic law, and I would require a runoff between the two top vote getters in the first election to be held 2 weeks after the first election. I would give the new elected president, picked by 51% of the voters, the power to nominate justices and judges to the Israeli courts, and with the advice and consent of 61 members of the Knesset, to appoint Israeli Supreme Court justices, appellate judges, and trial judges. Those justices and judges should then serve during good behavior until they resign or reach the mandatory retirement age. The justices should be selected 3 at a time for a 15-year term, after which they're ineligible for reappointment. The size of the Supreme Court should be fixed at 15 justices. Every elected president would select, with Knesset approval, no more than 3 or 6 justices. If a justice retires early, I think a replacement should be picked to fill out the stub part of the departed justice's 5-year term. Instead of secretive appointments committees picking new Supreme Court justices, I prefer an open and public process which completely eliminates Supreme Court justices from playing any role at all in picking their successors. This is the way Americans appoint new U.S. Supreme Court justices. The President of the United States nominates them, and a majority of the Senate has to confirm them. As a result, as famed political scientist Robert Dahl argued in the 1950s, the U.S. Supreme Court ultimately follows the national election returns. It is for this reason that there's no judicial oligarchy in the United States, even though our Supreme Court is incredibly powerful. It is often said that the U.S. Supreme Court follows the election returns. Israeli law ought also to make sure that the Supreme Court of Israel follows the election returns. The judicial confirmation process in the United States is very public, very open, and very democratic. All of a candidate's life works and past foibles are usually uncovered. Nonetheless, 80% of all Supreme Court nominees have been confirmed by the Senate. Americans vote for presidents and senators based in part on what kind of Supreme Court justices they will allow to be appointed. This reduces the counter-majoritarian difficulty that under the U.S. Constitution, an unelected Supreme Court strikes down acts of elected presidents, Congresses, and state officials. The whole process is very open, very public, and very democratic, unlike the committee appointment process used for picking Supreme Court justices now in Israel. Other major Western democracies also use a very public and political process to select new Supreme Court or Constitutional Court justices. For example, in Germany, half of the 16 justices of the German Constitutional Court are selected by a 2/3 majority of the lower house of parliament, and the other half are selected by a 2/3 majority of the upper house of parliament. This is obviously an open and democratic selection process. The German justices serve for 12-year non-renewable constitutional terms with a mandatory retirement age of 68. In France, 1/3 of the members of the Constitutional Council are selected by the President of the Republic, 1/3 are selected by the President of the National Assembly, and the final 1/3 are less selected by the President of the Senate. The French justices serve for 9-year non-renewable terms. Again, it's an open and democratic process. In Italy, 5 of the 15 justices are selected by the President of the Republic, 5 are elected by the 2 houses of Parliament, and 5 are elected by the Court of Cassation and the Council of State. The Italian Constitutional Court justices serve for non-renewable 9-year terms. In Brazil and Mexico, Supreme Court justices are nominated by the President and confirmed by the Senate, as in the United States. The only country that follows the Israeli system of involving Supreme Court justices in the appointment of their successors is the system in India, which is regarded as being widely illegitimate. It would be unrealistic in Israel to require more than 61 votes in the 120-member Knesset for confirmation or appointment to the Supreme Court of Israel. That's why I would have an elected president nominate and 61 members of the Knesset confirm Israeli Supreme Court justices. Unfortunately, I cannot support the idea of giving 61 members of the Knesset the authority to overturn Supreme Court justices, because I think those decisions should be guided by law and not by policy arguments. I'm afraid that involving the Knesset in the judicial process by giving it a power to overrule Supreme Court justices would violate the separation of legislative and judicial power. Article 33 of the Canadian Charter on Rights and Freedoms does actually allow both the Canadian national government and the Canadian provincial governments to override Canadian Supreme Court decisions. Article 33, which has been in place since 1982, has worked out very badly in Canada. It is essentially no longer used, and it's viewed as an embarrassment. The knowledge that a majority of the legislature can overturn Canadian Supreme Court decisions has actually made that court more activist, and Parliament in turn is hesitant on separation of powers grounds in overturning even the most egregious abuses of judicial power. I think I would also postpone consideration of reforming Israel's substantive constitutional law on standing, reasonableness review, or the status of basic laws in the Israeli constitutional system. I think reformers should leave it to a new and democratically selected Supreme Court, picked openly by an elected president and by 61 members of the Knesset, to change Israeli constitutional law as they see fit. Using a US-style process for choosing new Israeli Supreme Court justices is not a coup d'etat or a threat to checks and balances. To the contrary, it would give Israel more checks and balances than its constitution currently has. It would also eliminate the objection that an allegedly corrupt prime minister is attacking the rule of law, judicial independence, or the Supreme Court. No reasonable person could argue that importing the US system of judicial selection into Israeli constitutional law is an attack either on the Israeli Constitutional Court or on the rule of law or on judicial independence. Moreover, the Israeli Supreme Court would act at its own peril if it struck down a new basic law that directly involved the people of Israel in judicial selection by electing a president who would nominate all judges subject to confirmation by the Knesset. And those are the gist of my remarks. So I hope I've said enough controversial things at this point to trigger questions. I trust that I probably have. So I'm happy to answer questions from Yonatan and then from the audience.
Wonderful. Well, thank you very much, Professor Calabrese. That was interesting and insightful and a wonderful place to start. I'll remind the audience, now I'll continue the conversation with Professor Calabrese with a few questions of my own, but you're welcome to use the Q&A button to ask a few questions. And then when we're done with this part, we'll raise those. So first of all, I should say just a debt from beforehand. I forgot to mention the most important part of this conversation when I said that Professor Calabrese is a founder of the Federalist Society, that I didn't mention that I'm wearing my Federalist Society tie, which I feel is a very important part of that the audience ought to know. But moving on to more substantive matters, it's interesting, I think, that Professor Calabrese, you, I think, really addressed some of the, the most important and most contentious issues right now being debated in Israel. And I'll demonstrate that just by saying that, first of all, the two pieces of the proposal, the two elements of the proposal which have gone the most forward, which have moved ahead the most in the legislative process, and which means essentially that the coalition has been pushing the most sort of aggressively, has been that of judicial appointments and that of excluding basic laws from, or the semi-constitutional basic laws from the authority of judicial review of the court. And these are both issues that you've directly addressed. And right. and we'll delve into those in just a moment. And of course, the override clause and your reservations about the override clause, I think, interestingly enough, is also shared by many conservatives in Israel. And we've heard from the conservative side, including from certain members of the Kohelet Policy Forum, which is a conservative think tank very much sort of associated with these reforms, and they've said this is something that they'd be willing to compromise on, and not something that they think is critical. But let's start with the judicial nominations, because I think you, both in terms of your suggestion that you made and in terms of your description of what happens elsewhere in the world, in Western democracies, and you mentioned a few different European countries, and of course in the U.S. And also your suggestion ultimately that you have some kind of elected president, or maybe we could think of some other sort of similar mechanism, and whereby the coalition or a 61-person majority of the Knesset approves these appointments. Right now, what's happening in Israel is that those objecting to the reforms, the opposition to the reform, is claiming that the very notion of the coalition, the very notion of the winning, the majority of the legislature, the majority of parliament, the notion of the majority of parliament appointing judges and having that power is a terrible idea. It's something which is complete anathema to democracy. And we've actually seen that today, right now. I mean, as we've been talking, there were some news updates, and we had people from some of the opposition parties saying that no one from the left, and no one opposing the judicial reforms should compromise on this particular issue. And the idea of the coalition being able to appoint even one judge is completely unthinkable. So what do you say to that? And what do you say specifically to the concerns raised, which are involved with, usually, the concerns often raised, which are involved with political appointment of judges?
So I think political appointment of judges is essential to avoiding being governed by a judicial oligarchy. And I really think the Israeli Supreme Court, by playing such a big role in selecting its own successors, is a judicial oligarchy, kind of like the Guardian Council in Iran, which is not something one would want to emulate. So I think it's very important that democratic officials play the key role in picking judges. And I don't think justices or judges should be able to play any role at all in picking their own successors. One of the reasons I proposed that an elected president of Israel nominate judges and the Knesset, 61 members of the Knesset confirm them, is that would clearly create a system of checks and balances. But of course, 61 members of the Knesset today are only going to confirm fairly conservative judges. So the president can nominate until as long as he wants, but unless he nominates a conservative, those people won't be confirmed. And that's completely appropriate. This is the way we handle judicial nominations in the United States. Former President Donald Trump nominated and got confirmed 3 Supreme Court justices, one to fill the seat of Justice Scalia, who died 10 months before the presidential election, another to fill the seat of Justice Kennedy, who had been the swing justice on the court. And then a vacancy actually arose when Justice Ginsburg died in October of the presidential election year, and President Trump filled that vacancy with Justice Amy Coney Barrett. So I think that democratic appointment of justices is actually the norm, not only in the United States, but around the world. As I said, in Germany, democratic officials pick constitutional court justices. In France, democratic officials pick constitutional justices, justices. In Italy, 2/3 of the constitutional court justices are picked by democratic officials, and the other 3 by the ordinary courts. In all of Latin America, presidents nominate Supreme Court justices and Senates confirm them. This is true in Brazil and in Mexico. So I think that Israel is a real outlier among the countries of the world in not having elected politicians pick judges. And one of the things I should say is that, a big concern about judicial review is what gives a life tenured or a justice with a 15-year term, what gives them the authority to set aside the will of the people by telling the elected prime minister and the executive branch what to do, or by telling the Knesset what to do? And in the US constitutional law, this is called the counter-majoritarian difficulty. And the response to it has been that because presidents and senates pick new justices, ultimately the Supreme Court in the United States follows the election returns. And that's true of the German Constitutional Court, the French Constitutional Council, the Italian Constitutional Court, the Brazilian Supreme Federal Tribunal, the Mexican Supreme Court. It's basically true all over the world, except in Israel and India. So I think the current Israeli system is really an outlier.
One argument which is often raised, and I think it's a peculiar argument, at least in light of how many other countries do run things this way. But one argument that's been raised in Israel is that a more political system for appointing judges will result both in decreased judicial independence, or that it will destroy judicial independence, and that it will result in less professional judges, and that a political appointment process will damage the ability to have professional judges serving on the bench. What would you say to that?
So just drawing from the US experience, which I'm most familiar with, the appointment process to the US Supreme Court has been very political. Republican presidents and senates have appointed conservatives. Democratic presidents and senates have appointed liberals. But it's the process is the process has actually led to what I would call a turn toward excellence. Of the 9 members of the current US Supreme Court, 8 are graduates of Yale Law School, 4 are graduates of Yale Law School, 4 are graduates of Harvard Law School, and 1 is a graduate of Notre Dame Law School. So there has been a flight toward quality as a result of politics, because both Republican and Democratic presidents want to make it clear that although they're appointing justices who share their judicial philosophy, they're also appointing absolutely first-rate lawyers. And, you know, the United States has 200 law schools, and only 2 of them, Yale and Harvard, constitute 8 of the 9 Supreme Court justices. Most Supreme Court law clerks get picked from Yale and Harvard by those 8 justices. So the democratic process has in fact led to an insistence on high quality in terms of the justices who are picked. It hasn't led to cronyism or to the appointment of personal friends who might help in a corruption trial or something of that kind.
That's a wonderful point, and I think one that's often sort of overlooked in the Israeli debate around these things. I'll move for a moment to the question of reviewing basic laws or striking down basic laws, because you started off your comments with the sort of almost the assumption, the sort of foregone conclusion that the court may well strike down these amendments to their own powers, essentially, to whether it's a judicial selection process or whatever it is. Now, putting aside the speculation on what specifically will happen in Israel, could you speak a little bit about the propriety of, or the very notion of a court striking down what it sees as constitutional amendments, especially such amendments that relate to its own power, meaning that define or change the court's own power and the court's ability, or the correctness of the court getting involved with these things?
So I think it is highly improper for a Supreme Court to strike down a basic law or constitutional amendment, in essence, that alters the judicial selection process. One of the oldest rules of English and American law is that no man should be a judge in his own case. And similarly, the Supreme Court should not be judges of the appointment process to the Supreme Court. That being said, in India, Parliament has passed 4 constitutional amendments taking away from the Indian Supreme Court the power to select new justices. And in 4 cases, the Indian Supreme Court has held those constitutional amendments to be unconstitutional. So in the one other country in the world that has a system like Israel's, the Supreme Court has not hesitated to strike down as unconstitutional changes to the judicial selection process. If that happens, of course, there's a kind of constitutional crisis because 61 members of the Knesset will pass the basic law, and the Knesset, Israel has a system of parliamentary supremacy, but if the Supreme Court holds judicial selection law unconstitutional, people will be unsure about what to do next. And I'm not sure that Prime Minister Netanyahu would be willing to continue the fight at that point. That's why I suggested the idea of focusing on one simple reform like an elected president who nominates justices who are confirmed by 61 members of the Knesset, because then the people of Israel would play a direct role in judicial selection, and that might be popular. I think if there's a standoff between the government and an Israeli Supreme Court that has struck down a judicial selection basic law, I think that if there's a standoff between the two, it will matter greatly what public opinion is. And right now, public opinion is, at least in the United States, among Jewish Americans, is very hostile to these reforms. And I know there's a lot of hostility to them in Israel. I think that I think the most prudent thing to do is to focus on judicial selection, because that's really the key. I mean, it's the justices who are going to review the reasonableness law. It's the justices who are going to review basic laws and whether they can be overturned or not. I mean, the key question is the composition of the court. So rather than proceeding with all the other laws, which seem to some to be an attack on judicial independence, I would focus in narrowly just on judicial selection and try to come up with a proposal that's popular with the people of Israel, because I do think there's a real likelihood of a standoff between the government and a Supreme Court that struck down a judicial selection law.
Because you mentioned the Indian case and the sort of famous standoff over there, I will just make, of course, a super important distinction, which of course you know that we've discussed in the past, which of course that India has a constitution, and the legal grounds for doing what happened in India, putting aside all the other dissimilarities between Israel and India and other Western democratic countries. But the doctrine which was used there, called the basic structure doctrine, at least had this foothold in the idea that you have a constitution and it has a basic structure, and the amending power can't, so this was their argument, the amending power can't amend the basic structure of the constitution. But in the Israeli context, when there is no constitution, when the basic laws are sort of highly controversial pseudo-constitution, and I should even note that when the court originally in 1995, in the 1995 Hamizrahi case, when the Israeli Supreme Court decided that Israel had a constitution and decided that based on this quasi-constitution, Israel, the court has the power to strike down laws, it did so based on the idea that it could do so only when laws violate a rule set out in a basic law, when ordinary laws violate basic laws. And one of the arguments in favor of this that Justice Aharon Barak made at the time, one of the arguments in favor of this was precisely that the basic laws can be so easily amended and changed and legislated by the Knesset, and therefore the Knesset still retains full power. And that brings me to a really important question to you, sort of the next question I had on my mind, but it relates directly to this, is there anywhere else in the world that judges, or I should say in the democratic world, that judges claim the power to strike down legislation without an established, or what we should call a conventional written constitution? Is there anywhere else where this happens?
I think the answer to that is essentially no. The United Kingdom does not have a written constitution, and the Supreme Court of the United Kingdom has been quite active in recent years. It held that Brexit couldn't be accomplished just by the referendum. It required an act of parliament. It also struck down former Prime Minister Boris Johnson's use of the prerogative power to prorogue parliament and end parliamentary debate. But in neither of those cases was the UK Supreme Court striking down an act of parliament. And I can't imagine the UK Supreme Court striking down an act of parliament, given the principle of parliamentary supremacy that's central in English law. Your points about India are very well taken. I mean, not only does India have a written constitution, it has a very lengthy written Bill of Rights. And it also is clear that the framers of the Indian Constitution intended for there to be judicial review. None of that is present in Israel. In Israel, the first Knesset chose with the Harari resolution to basically have the Knesset wear two hats. As one hat, it acts as the legislature of Israel, and with its other hat, it constructs through passing basic laws by 61 votes, it constructs a constitution of Israel. So the basic laws that the Knesset has passed are constitutional because of the Harari resolution, and they trump other laws, which, as you said, is what allowed Prime Minister Barak to institute judicial review in the first place. There's just nothing Chief Justice, I'm sorry. There's just nothing in Israeli history that supports the idea of basic laws themselves being unconstitutional, unless one thinks that the Declaration of Independence of Israel is somehow part of the Constitution of Israel. And I have heard some people suggest that, but it's not, I believe, a widely held viewpoint. So, yeah, I think it's really what the Israeli Supreme Court has done is really quite extraordinary. And I think that the proponents of judicial reform need to have public opinion on their side, both in Israel and in the United States, to defang the Israeli Supreme Court.
I think the point about public opinion is well taken, and there are certainly, I think, some lessons learned here for the Israeli political right. But that's a more sort of political PR discussion more than it is a public opinion discussion, more than it is a legal discussion. Before I'm almost done with my grilling you, and in a moment we'll open up the floor to questions. And I see we already have a nice pile of questions here from the audience. I'll ask another slightly more abstract question, because so much of the debate in Israel surrounds the question of what is democracy and how does one define democracy, and sort of what is the core element of democracy. And even though, of course, this is a big question and possibly a whole an entirely other discussion, I wanted to ask you, first of all, do you see anything in the reforms which would justify a claim that they somehow undermine democracy? And second of all, in light of that, how would you define, what are sort of the basic principles of democracy, which, once those are violated, then a country is no longer democratic? And I should say to the audience, one of the things that I have in mind is an important paper or important opinion recently written by Professor Calabrese and Professor Akil Amar about the Republican government clause in the U.S. Constitution, whereby the U.S. Constitution actually has a rule that says that the states have to have a Republican government, and Republican government was the word that we used back in those days in the same way that we use democracy today. Back then, no one said democracy. That democracy meant Greek democracy or direct democracy, and Republican government back then meant sort of representative democracy the way we use it today. So that's one of the things that I have in mind when I'm asking this question. So just to summarize, what do you say to those that say that the current proposals undermine democracy, and how would you define sort of the core tenets of any democracy?
Well, I think the core tenet of a democracy is that every branch of government has to trace its legitimacy back to the people who have enacted it, and I guess back to the people. And so I think that in the United States, democracy works because the people elect the House of Representatives, the people elect the Senate, the people elect the president, and presidents and senates basically pick Supreme Court justices. And so the Supreme Court follows the election returns. And there's just no question after 234 years of American history that the Supreme Court follows the election returns. So in that sense, there is a democratic mandate for the court, which it exercises when it strikes laws down as unconstitutional. When the justices can veto their own successors, they become like the Guardian Council in Iran. They become an undemocratic institution and a problematic institution. I think that the essence, one of the claims that's been, I think one of the problems with the judicial reforms as they've been put forward is that they tackle so many different subjects at once that critics think that they are an attempt to eliminate the independence of the judiciary. And that's why I would focus in on judicial selection in particular, which I think is really the key thing that is at stake. And I think that would reduce the fear that the independence of the judiciary was being attacked. But I think that the Supreme Court, the government, and the Knesset all have to have a democratic mandate in order to legitimately function. James Madison in the 51st Federalist paper basically described the problem in words that I will quote because I think they are so beautifully written and so poetic. Madison said that in order to, Madison was addressing how it was that the Constitution would ultimately be enforced. And he said it would be enforced by a system where the people chose the Congress, the president, and the Congress and the Senate chose Supreme Court justices. And so every branch would have its own line of legitimacy to the people. That's why I suggested an elected president as well as the 61 members of the Knesset in picking new justices. But Madison said the following about this. He said, ambition must be made to counteract ambition. The interest of the man must be connected with the constitutional rights of the place. It may be a reflection on human nature that such devices should be necessary to control the abuses of government. But what is government itself but the greatest of all reflections on human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. A dependence on the people, i.e. elections, is no doubt the primary control on the government, but experience has taught mankind the necessity of auxiliary precautions. And the auxiliary precaution that Madison had in mind is separate lines of legitimacy from the people for the Congress, the president, and the federal courts.
Thank you very much. While obviously I do have any questions of my own, I'm going to stop hogging the questions and pass some questions on from the Q&A box. And we've had quite a few questions from our audience. I'm going to try and bring together a few questions when I see they're of a similar nature. So one question that seems to be recurring regards the lack of a constitution in Israel. And this question kind of has two sides to it. One side is, isn't the solution that Israel should have a constitution? Isn't that the most sort of obvious natural solution? We just need to have a proper constitution that enshrines basic rights, that enshrines the institutional arrangements between the different branches of government, et cetera, isn't this part of, at least part of the solution? And then the other side of that question is, in the absence of a constitution, a real constitution that enshrines fundamental rights and that protects minorities and protects individual liberty, et cetera, is there not a greater justification for judicial intervention, or is there not a greater danger of governmental abuse of power and violating fundamental rights, et cetera? So this is a dull question about the lack of an Israeli constitution.
So let me see if I can answer this completely in one answer. You tell me if I've missed the second half of the question. Should Israel have a written constitution? That was hotly debated in the first Knesset. There were those who thought the first Knesset was a constituent assembly that was supposed to write a constitution. And there were those, like I think Prime Minister David Ben-Gurion, who wanted no part of writing a constitution and wanted a British system of parliamentary supremacy. And Ben-Gurion got his way, and there's no written constitution, but the Harari resolution passed by the first Knesset said that the Knesset can wear two hats. It can be both a constitutional convention and a legislature. And when it's wearing its hat as a constitutional convention, it can enact basic laws by a 61 vote margin out of 120 members. I think in an ideal world, it would be a good thing if Israel did have a written constitution. But I think that the same things that made it impossible to adopt a written constitution back in 1948 would make it very hard to adopt a written constitution today. There would be fundamental disagreement about how to reconcile Israel's status as a Jewish state with equal protection for Palestinians and for others living within Israel. I think there would be tremendous debate over that. I think there would be a lot of debate over how much protection should be given to religious liberty and the scope of that. And so I fear that embarking on a constitution writing project would consume an enormous amount of time and energy and would end in a stalemate today, just as it ended in a stalemate at the founding of the country. That's why I would just focus in on one change, which is a basic law providing for an elected president who nominates judges. That solves the problem of the illegitimacy of the Israeli Supreme Court by allowing for a check on the court without opening up the whole can of worms of religious freedom, the character of Israel as a Jewish state, and all sorts of other things. I think part of the reason that the judicial reform proposals have run into so much hot water is because they try to do so much all at once. And I would recommend postponing the question of reasonableness review or changing standing rules or things like that to another time, and just focus on the central issue of judicial selection. Because frankly, if you get judicial selection right, the court itself will ultimately change the case law to accommodate that. And we've seen that in the United States. The justices appointed by President Trump overruled Roe versus Wade and made fundamental changes. So my recommendation is to focus on judicial selection. Does that fully answer your question, or was there part of it that I missed?
Yeah, I think close enough.
Okay.
Your answer actually brings up or relates to quite a few other of the questions that were asked here. So there's two that come to mind, and I'll start with one which is pretty specific. Mr. Ido Bar is asking, considering our president is a mainly ceremonial role at the moment, and I think there's also a question of whether, how much the public will be receptive to this idea of really fundamentally changing the selection process for the president, not only the judicial selection process. The question is, why not use a committee, meaning in very much a similar way that it exists now, in lieu of the sort of presidential suggestion that you've raised, and still have the Knesset approve or reject the committee's nomination?
I think that would be a perfectly good solution. I think you could do that. I think that the government should nominate justices and judges, but that they should be confirmed by a majority of the Knesset. So I think that would be a good solution. The advantage to the elected president is that everyone would vote for the president knowing that that person would pick judges. But one could certainly have the appointments committee refer judges to the Knesset and have them only be approved if by a majority of the committee, by a majority of the Knesset. I would take the 3 Supreme Court justices who are currently on the Judicial Appointments Committee off of that committee, because I think justices face a conflict of interest when it comes to picking their successors. Every justice wants to pick a successor who will enshrine their decisions into law for all time. And, you know, that's not necessarily what the country wants or what the people of Israel want.
Your last sentence about judges wanting to enshrine their legacy is heretical in some circles in Israel, meaning, of course, judges on a judicial selection committee could only make professional decisions and only weigh candidates according to their professional qualities. There's one actually important clarification that I want to make also for our audience, for those that aren't Israeli jurists, and for a more accurate picture, the Harari resolution in the early 1950s in Israel merely said that the basic laws will kind of serve as a draft for the Israeli future constitution, and the notion that in fact the Knesset was exercising sort of 2 different functions, a sort of ordinary legislative function and then a sort of constituent function, so to speak, was a sort of later elaboration, first raised by certain academics and then sort of ultimately adopted by the Supreme Court. But certainly until the early 1990s, there was no sort of legal understanding that the basic laws had any kind of constitutional weight or value. And in fact, of course, the court ruled on many occasions that they had no constitutional weight. But certainly one of the arguments that has been advanced by the court is that indeed these have ultimately or eventually gained some kind of constitutional status. I should also say that over the years, and even to this day, basic laws are passed in an ordinary majority, in any majority, including the basic law of human right and of human liberty and dignity, human dignity and liberty, which is considered sort of the bedrock of the constitutional revolution in Israel in 1992 and 1995. This was also passed in a majority of 32 members of Knesset versus 21, I think. Not even a majority of legislators were in the room when the law passed. That's just mentioning it in passing.
And if I can respond, I have tried to learn as much about Israeli constitutional law as I can, but I have to concede my limits. I'm an American constitutional expert, and there's only so much that I know about Israel. A lot of what I know about is reading United Mizrahi Bank and Justice Barak's view about the Harari resolution. Whether Barak is right about that or not is debatable. My impression is that there was a decision, the Bergman case in maybe 1969 or so, where something was struck down as violating a basic law. And some people wondered if that Bergman was going to be the Marbury versus Madison of Israel. And it turned out not to be. It's United Mizrahi Bank that was the Marbury versus Madison. I don't even remember what was at issue in Bergman or what the basic law was. Maybe you can enlighten the audience on that. But that is sort of the precedent. There also are quasi-constitutional rulings like the Kolam ruling on freedom of speech in the 1950s, which is a very important statement about freedom of expression.
Absolutely. I should say more. I think you raise a more general point. I won't elaborate on the Bergman decision or on more about that, because this is because you're the guest and we want to hear you and not me. Okay. I will say that the Israel Law and Liberty Forum will soon be publishing an English translation of a really important paper written by Chief Justice Moshe Landau in 1995, in 1996, as a response to the Hamizrahi case. And he was the author of the Bergman case. And there he is extremely critical, really, vehemently critical of the Hamizrahi case. This is a retired Chief Justice, extremely critical of the Hamizrahi case, and he spells out both why it's not Marbury versus Madison, and why it's not justified by Bergman, and why the Knesset doesn't maintain constituent power, et cetera. So I think you'll find that of interest, and maybe we'll send it out also. We'll surely send it out in our newsletter. So yet another reason for our audience to sign up to the newsletter. There's another point which you raised, which is extremely important, which is that Israel is a small country, which the primary language of which is not English, and it's not a country which is sort of intensely studied abroad. It's not some massive bastion of constitutional scholarship, which is an example to the world or whatever it is. And this raises serious barriers. And this also has to do with, the understanding abroad of constitutional scholars of what happens in Israel tends to be limited, especially certainly on the street and sort of, just the layman's understanding, et cetera. I want to raise a question that some of the audience have raised over here with regard to the UK and the UK legal system, and specifically the UK method of selecting judges, because and you've addressed this sort of partially, but as we know, in the UK, judges are heavily involved in the selection of especially of all judges, but especially even Supreme Court judges. So what would you say to that?
So yes, you're right that in addition to India and Israel, the UK is the other country in the world where judges play an active role in judicial selection. But my impression is that the judges in the UK are much more deferential to the democratically elected members of the Judicial Appointment Council than is the case in either Israel or India. Again, it's hard to be an expert on UK law as well as Israeli law, but my strong impression is that the UK judges are to a significant extent more deferential. I do want to say that vis-a-vis Mizrahi Bank and the Bergman case and Kolam and all of that, I do think that judicial review properly checked and balanced can be an important and valuable feature of a constitutional democracy, because legislatures can ride roughshod over the rights of minorities, and elected governments can do the same thing. And the fact that in the United States, the president can only do something important by getting the votes of 5 out of 9 Supreme Court justices, most of whom were picked by his predecessors, is a real limit on the president's power. So I think that judicial review properly checked and balanced is in fact a good thing. The problem in India is that in Israel is that judicial review is not checked or balanced at all. It's run riot, and checks and balances applies not only to the Knesset and the government, it applies to the Supreme Court as well. And the Supreme Court needs to be checked and balanced, and right now it isn't.
That's a wonderful point, of course, about checks and balances. And I think it's Judge Richard Posner said that the Israeli Supreme Court thinks that it's the only one doing the checking and the balancing, with no one else entitled to check and balance the court. The point about the UK, I think, is excellent, and specifically your point about the court being more deferential, in the sense that most likely, if the Israeli court had conducted itself differently, then no one would be talking about judicial nominations, meaning there's a sort of spectrum. And on one end is the more powerful the court is, the less deferential it is, the more interventionist it is, and the more it arrogates to itself more power that wasn't explicitly granted to it, then the public will expect more direct political involvement in the nominations process. And of course, vice versa, meaning the public can live with a professional, so-called professional process when the court is less involved and powerful.
I agree with that totally. I should also mention that the United States is itself not totally free of judicial involvement in judicial selection for the following reason. U.S. Supreme Court justices strategically retire from the Supreme Court when a president they like is in office and can appoint their successor. And so that gives the departing justice some say over who their successor is. Not as much say as there is in Israel, but some say. And that it is also the case that U.S. Supreme Court justices strategically die in office during the presidency of the party opposite to the one that picked them. So Justice Scalia died in office during the Obama presidency, and Justice Ginsburg died in office during the Trump presidency. One of my colleagues has done a thorough examination of all the justices who died in office and has proven that justices die in office strategically, basically to avoid the appointment of a successor who will change what they do. That's why I favor the idea of a 15-year term with 3 seats coming open every 3 years. And if a justice leaves early, just fill the seat for the stub remainder of the term, because that would eliminate strategic retirement. And I do think the United States suffers from strategic retirement, and that diminishes the democratic accountability of the U.S. Supreme Court. So it's not as if the U.S. doesn't have problems with this issue also.
Thank you for that. I think there's a really important question that has been asked a few times here, which sort of speaks to the heart of the matter. One way I think that's been asked here is by Mr. Shimon Waldvogel, who is he's asked about the struggle in Israel to define the role of religion in political life and state, and considering the reverence of the American system for freedom of religion. Isn't there a problem when we look at Israel in terms of protection of religious freedom, or as some tend to say in Israel, freedom from religion, especially in light, and this connects to another question that was asked, especially in light of the fact that a significant part of Israeli population don't necessarily believe in, so goes the claim, don't necessarily believe in democratic norms constituting sort of the supreme law of the land, but rather religious law. So the question is, and this mixes up a whole bunch of issues, but I think it's important because some claim that the entire objection to the proposals and to the judicial reform are really just a mask for the larger concerns within the secular community or within some other parts of the community about the religious right, or about religious parties having so much power, which would be unchecked by a court. So what would you say to these concerns?
I would say that's a very accurate diagnosis of why the reforms have been as controversial as they have been. And religious warfare has been with us for centuries, and it hasn't completely gone away. And secular elites in the United States were very, very upset about President Trump's Supreme Court appointments, which have cemented a 6 justice out of 9 majority that favors religious freedom and that protects the free exercise of religion. So I think that is probably one of the things that motivates the opposition. I think precisely because of that, it's desirable to narrow instead of seeming to attack judicial independence by considering 4 or 5 reforms all at once. I think that focusing just on judicial selection, where the case is the strongest and where Israel is a real outlier compared to other countries in the world, would help to make the reforms more saleable and supported by the public. But yes, I think you're absolutely right. That is probably one of the things that is generating opposition. Of course, you asked me before about whether Israel should have a written constitution, and I said yes, but for the same reasons they couldn't draft one in 1948, they'd have Israel would have a terrible time drafting one today. And part of the reason is religion, basically. So, I think that
Absolutely.
the decision to just sort of focus in on basic laws is therefore a defensible one.
I'll exceed my authority and offer half an observation on this issue of the religious context. Obviously, there's much to be said. I'll just answer that at least one of the common answers to that kind of question is that nothing is stopping the large sort of secular, traditional, or sort of non-religious or non-ultra-Orthodox majority in Israel from forming a coalition. And one of the arguments is that less power to the court and the political left have undoubtedly been the main beneficiaries of the court's enormous power over the past 30 years. And one of the arguments is that this fuels and incentivizes and encourages the left's, the political left's intransience and the political left's reluctance to join coalitions, to join in coalitions with right-wing governments or center-right governments or whatever it is, because they can get their way or they can impose policy through alternative means, not through the political process, not through the democratic process, but rather through the courts and their sort of forward outposts. And this is an argument made by left-wing professors such as Professor Meni Mautner, meaning this is not a conspiracy theory. This is just this is kind of the way things have been working in Israel for many years. And one of the arguments is once the court actually is tamed and has less legislative and less sort of policy-making powers, then there will actually be more room for compromises, including historic compromises between the different parts of Israeli society. And that's just a general observation.
Yeah, thank you. That's a really interesting observation. I have two thoughts about it. First, I should mention that the U.S. Supreme Court was very hostile to religion from 1962, when it banned prayer in public schools, until the confirmation of the Trump justices within the last 7 years. And there was a lot of Supreme Court case law that was just plain anti-religious. So, for example, there were cases saying that displays of the Ten Commandments were unconstitutional because they were an establishment of religion, and cases saying that holiday displays of creches and Stars of David were unconstitutional because they were establishments of religion, which is ridiculous, frankly. There were even people who claimed that the government shouldn't fund individuals going to religious schools because government money should never go to a religious institution. Now, all of that jurisprudence, which existed really up into the 2000s, has now been swept away by the new majority on the Supreme Court. So this has been a big issue in the United States as well. I think you're right that the existence of a liberal Supreme Court majority creates and eliminates an incentive for Israelis on the left to organize politically, to join coalitions, and to just rely on the court to protect their rights. I should also mention that the existence of the liberal majority on the court does allow someone like Prime Minister Netanyahu to run against the court, to say that he'll support judicial reform, but then when the Supreme Court strikes down judicial reform, say, well, I tried and I couldn't do it. And for years, we had Republican candidates in the United States who argued against the legality of abortion under any circumstances. And it was costless to argue that because the courts would strike down any laws that banned abortion. And so Republicans, endorsed the strictest laws banning abortion possible, knowing the courts would save them from themselves. And I worry that Netanyahu has endorsed judicial reform only because he knows the court will strike it down, and then he will be able to say, well, I tried and it didn't work. So yes, there are all sorts of second order effects of having an entrenched majority like that in the court. And then finally, I think you're absolutely right that the more powerful the Supreme Court becomes, the more necessary it is that it be democratically accountable. And if the Supreme Court had not issued the Mizrahi Bank case, probably the issue of judicial reform wouldn't have surfaced. So that's certainly true too.
Thank you. Those are excellent points. I think that argument is also often echoed in Israel, that we see the right as well sort of allowing itself to engage in certain types of legislation or behavior or proposals, knowing full well that these will be sort of struck down either by the court or by the legal counsel to the government or whatever it is. But of course, that's yet a stronger argument against that kind of judicial intervention, which just encourages sort of frivolous or reckless or irresponsible behavior. And some have argued, and I've recently seen this in a book called Against Constitutionalism by Professor Laughlin, I think is his name, that it creates a serious type of stagnation within political discourse when so much of the conversation becomes about what's legal and what's not, instead of what's a good policy or what's smart or what's beneficial and what's not. A quick housekeeping comment. We have about 10 or 12 minutes left ahead of us. Some people have asked, so I'll answer. We will be putting this video up on our YouTube channel for the Law and Liberty Forum, and we will send out the video to everybody who have registered to this call, and I assume that video will also have closed captions. I don't know that we're intending to publish a transcript of any kind. Perhaps Professor Calabrese will want to send over at least his opening remarks if he chooses, or if he happens to have them written. But at the very least, we'll have the video up on our site, and anyone who wants to come back can do so. Because we've sort of allowed ourselves to flirt with the political questions and not only the legal questions. So I'll convey a question here asked by Dennis Karpf, and he's asking, how does Professor Calabrese suggest that rollout for public opinion support for reform be improved? Meaning, how do we improve public opinion support for the forum, I suppose, both in Israel and possibly elsewhere, like in the US?
Well, I think that there are two ways to do it. The first is to just focus on judicial selection and not the other issues that are the subject of debate. Not that I'm very sympathetic to what the other issues are. I agree with the government on reasonableness review. I agree with the government on the court not overturning basic laws. I agree that standing doctrine should be restored and all of that. But I think that by tackling a bunch of questions at once, it makes it seem as if the government is trying to undermine an independent judiciary. And that's what's got so many American Jewish community members really upset. So I think and I think if you focus on judicial selection and how unusual Israel's process is compared to other countries in the world, you know, that's something that would really help a great deal. I'm sorry, what was the rest of the other part of the question again? Can you repeat it?
No, I think you addressed it. Sort of how we can better, affect public opinion in support of the reforms.
And, my other suggestion was have an elected president and let people vote for a president who nominates judges that have to be confirmed by 61 members of the Knesset. I realize that's an eccentric reform that probably won't go anywhere, but it would give Israelis the feeling that they had some involvement in the process.
Well, I'll allow myself to push back a tiny bit, not on that specific proposal, which I think is fine and should be acceptable. But I think part of the big conversation here, and this has been echoed in a number of outlets now or a number of sources, part of the debate is really about the very notion of a democratic electorate having power to make decisions at all. Meaning and that's why I think that many of the opponents to reform in Israel would also oppose a proposal like yours, because they would say it's more of the same. We don't want the majority of the public being able to affect fundamental questions of fundamental rights of minorities. Meaning, it's this idea of tyranny of the majority, which ultimately seems to trump all other considerations, including traditional established notions of democratic, accountable self-government. Meaning this idea of the danger of the tyranny of the majority seems to trump all other considerations. And in that sense, I think your proposal would less likely be acceptable to many of the opponents of reforms in Israel.
Right. So, the problem of tyranny of the majority has a counter problem, and that is tyranny of the minority. And when you empower the Supreme Court to the degree that the Israeli Supreme Court is currently empowered, you run the risk of having tyranny of a minority. What I like about having multiple different electoral systems is that they allow the majority will to prevail over time, but not necessarily for the passions of the moment to prevail instantaneously. And I should say that Israel, because you can pass a basic law with 61 votes in the Knesset, if the Israeli Supreme Court were to stop striking down basic laws as unconstitutional, then Israel would have what might be called a form of second look judicial review. And that's actually present in other countries in the world. I mean, Britain now has second look judicial review. The British courts enforce the European Convention on Human Rights and Freedoms, and they also issue decisions like the proroguing decision, but Parliament can override those decisions if it wants to do so. And in Canada, not only does Section 33 allow for overriding constitutional decisions for 5 years, but Section 1 of the Canadian Charter of Rights and Freedoms says that that the rights guaranteed in the Charter are subject to such reasonable limitations as may be necessary in a democratic society. So Canada, at least formally, has a system of second look judicial review. And second look judicial review, therefore, is a very plausible form of judicial review to have, and it would prevent a rash majority from legislating by reviewing something and requiring the Knesset to take a second look at the problem.
Excellent. Thank you. Okay, we have a few last minutes left. I have to choose between either Sophie's choice between all these excellent questions being asked by the audience, and obviously I, of course, should have mentioned this at the beginning. Of course, we won't have time to answer all of the excellent questions being raised. One suggestion here is that we should bring Akil Amar for a conversation about constitutional issues. So maybe you'll help us out with that. We'll
I would strongly favor that. Akil and I co-teach a seminar every fall on constitutional law at Yale Law School. And I also teach a comparative constitutional law seminar in Yale College in the political science department every fall. So I actually divide my time between Yale in the fall and Northwestern in the winter and spring. And Akil is one of the constitutional scholars who I most admire. I would say he's one of the, I would describe him as being one of the two or three best constitutional scholars in the United States. The difficulty with Professor Amar is that he is focused completely on US constitutional law and not comparative constitutional law. For a while, he co-taught comparative constitutional law with me, but he just never developed a real interest in it. I'm interested in comparative constitutional law because my father was a 9-year-old boy and my grandparents were 40 when they left fascist Italy in September of 1939 to flee to the United States. I'm of Jewish origin. I'm half European, half Italian, and of Jewish origin. And so an interest in comparative law comes very naturally to me. But regrettably, Americans are very ignorant about comparative constitutional law. As you probably know, in most countries in the world, people speak 2 or 3 languages. In the United States, people only speak English. And it's in part because the country is so big and you have to travel a distance to get to a place where another language is spoken. So the same parochialism that causes Americans only to speak English also causes Americans like Akhil Amar to focus only on US constitutional law and not on foreign constitutional law, which is very, very interesting and revealing.
In some ways, at least, that echoes part of the challenge here in Israel, which I sort of mentioned earlier, but I think is in much larger proportion, is that Israel, there's no other country in the world that speaks Hebrew, and Israelis don't have any sort of easy, natural access to see other countries and other systems of government, other legal systems. So Israelis tend to be extremely ignorant about what happens in other countries. And, in Israel, you can advance an argument about political appointments of judges, meaning the end of judicial independence, where at the same time, countries all over the world do it, and these are established democratic countries, and there's a type of ignorance about that. But the ignorance is two-directional, because for many, many people around the world, both the lay people and scholars, Israel is just, a tiny dot on the map. It's not similar to anywhere else. They don't speak the same language as anywhere else. They don't have even the kind of affinity of a very, very similar legal system. That's definitely part of the challenge we face. And what I usually counsel people from abroad is to sort of reserve judgment and take things a bit with a grain of salt, because usually things are a little bit more complicated than people tend to appreciate.
I should add, as I said at the beginning of my remarks, I'm a first cousin twice removed of Guido Tedeschi, and I have family members living in Israel. And so I've been to Israel, and I have a real personal interest in Israel. And when I did my book on the G20 nations that were constitutional democracies, I snuck Israel into the list, even though it's not a G20 nation, because I am very partial to Israel and very supportive of it.
That's it. And of course, you do know far more about Israeli constitutional law and history than probably almost any constitutional scholar outside of Israel, and that's part of the reason, of course, why your perspective here is so much enormously appreciated. Okay, I'm going to pose one last closing question to you, which will roll together a few questions that have been asked, and you can address them however you see fit. So, sure. I'll address two things that I'm not sure that the reforms are actually addressing at all. So some of the questions have asked about the kind of threshold conditions that are usually exist in other judiciaries, both that of justiciability, or the political question doctrine, and that of standing, or in the US, we call it cases and controversies, and sort of the abolition of these two sort of standard conditions for adjudication, which by the Israeli Supreme Court, whereby the Supreme Court has really sort of destroyed the idea, or done away with the idea, annulled the idea that cases, litigants must have standing, and the cases must be justiciable, et cetera. So that's sort of question one. And part two of the question, which really isn't a part two, it's just another question, is that some people have asked here about the notion that courts can strike down laws without any statutory basis, without any constitutional basis, but merely sort of on the grounds of them violating some kind of fundamental norm of democracy, or fundamental norm of human rights. This is something that has been echoed in the past in Israeli jurisprudence. It's been echoed, at least in minority opinions, in other countries as well. So this idea, and certainly by scholars, that courts can struck down, a duly enacted law of parliament merely because or I should say, not merely, solely because it violates the judge's understanding of some fundamental democratic norm. So those are the two questions: the threshold conditions and courts striking down.
Those are excellent questions, and I think the Israeli Supreme Court made a huge mistake by relaxing traditional standing rules. I think standing rules are fundamental to courts being legitimate. Having standing in the sense of suffering the legal injury that's caused by the defendant and that can be redressed by a court is critical. And standing doctrine is followed very, very strictly by the US Supreme Court. Justice Scalia led the way on that, and there is tremendous support for strict standing doctrine in the United States. And I think the absence of standing doctrine in Israel is scandalous. On the political question doctrine, the political question doctrine is very much alive in the United States. And one of the things that is said to raise a political question is whether a constitutional amendment was validly ratified. it's up to Congress to determine whether a constitutional amendment is validly ratified. So that goes to the question of judicial review of basic laws. There really are only two ways of responding to the Israeli Supreme Court. One is by passing a basic law, and the other is by somehow removing its members. I think that review of the constitutionality of basic laws or constitutional amendments should be viewed as being a political question. The final thing is, if you do pass judicial reform, judicial selection reform, and if the Israeli Supreme Court does strike it down as unconstitutional, what I would recommend that the government do is cut off all funding for the judges' salaries and for the court until the court changes its mind. Because the most ancient power of the legislature is the power of the purse. That's the power which allowed Parliament to triumph over English kings. So I think a decision and an invalidation of a judicial selection reform should be met with cutting off all funding for the courts, including the judges' salaries. That's, I know, a controversial idea, but that's the only way I can think of really getting their attention.
That really is controversial and I think thought-provoking. Certainly something which has been occasionally floated in Israel, but also has its own sort of statutory challenges. But in fact, you raise a really important question, and I'd be glad if sort of to finish, you relate to that as well. Going down that specific avenue of sort of how do the elected branches cope with a sort of clear breach of authority of this magnitude by the courts, like the example that you gave, where the courts simply invalidate the basic law to change the judicial nominations process. So one suggestion that you've raised has to do with the funding of the court itself and the judges' salaries, et cetera. Of course, it's the funding of everything. You could turn off the lights, just stop funding electricity for the courts too.
Right.
But another suggestion, which is sometimes floated, is the sort of Jacksonian response, referring to President Jackson, of just ignoring or violating the Supreme Court decision, just saying, okay, the Supreme Court has decided so, but we're not going to adhere to this particular decision because we don't think it's valid and we don't think it's lawful. And of course, usually when that kind of suggestion is raised, it's met with outcries of violations of the rule of law, outcries of sort of, and perhaps justifiably, but I'd be interested to hear what you think of that. And that's to close.
Yeah. So I think that in a really extreme case, and I think the Supreme Court of Israel striking down judicial selection reform would be a really extreme case. I think that the court's decision can be treated as a nullity by the executive branch. But it has to be a really extreme case. And you also have to have public opinion behind you. And I think that the best way to get public opinion behind you is to just focus in on judicial selection and let the other stuff get taken care of when new judges come on the court and change the doctrine. Because you will need, if the Israeli Supreme Court strikes down judicial selection reform, you will have a real test of will between the court and the government, and having public support, including support among the Jewish community in the United States, is really crucial. And I would emphasize that the court as it currently is constituted is really like the Guardian Council in Iran, that is an anti-democratic feature that's grafted onto the Constitution and that's illegitimate.
Thank you very, very, very much to Professor Stephen Calabrese. Thank you very much to our audience today. Thank you for joining. It was lovely having you on, Professor Calabrese.
Thank you very much. This was a tremendous amount of fun. Your questions were wonderful. This is a very interesting and very important debate, and I'm very proud and happy to be a part of it. So thank you.
Thank you very much. To our audience, I'll just remind you, you can scroll up the chat and you can see that we've sent a few links to register for our newsletter. You can see our Twitter channel or our YouTube channel over there. We also sent a kind of spreadsheet of a whole bunch of different resources or recent sources on the legal reform in Israel in English. Thank you very much to everyone. That's it for today. Enjoy the rest of your day and your week.